Well, hi everyone. I'm John Deirdre, and welcome to our podcast. Tonight's topic is legal work in the New York State Supreme Court. And we are delighted to have an attorney who has worked as an attorney in the court system in our state for 28 years. And she has a vast amount of experience, and I thought it would be very beneficial for potential clients who would eventually have some kind of a litigated case and would have to eventually go to trial to benefit from the experience of someone who's been on the inside for almost 3 decades. So I am genuinely delighted to introduce Deirdre O'Connor. Welcome, Deirdre, and thanks so much for being here.
Hi, John. Thanks for having me. I'm delighted to be here.
Let's start with your background, since we're talking about your experience as an attorney. So give some background as you work in the court system in New York State.
Well, I worked in Bronx Supreme for 23 years, and then I worked in Brooklyn Criminal for 5 years. While I was in Bronx Supreme, I was in the discovery part. I worked for judges, different judges, and mostly in the discovery part, as we call it.
So you use a term, and I think they're always interesting to educate basically our clientele. So what does a discovery part mean?
Well, I guess I should say a conference part. That's where the attorneys come in when they start their case, and we move it along. We conference with them, see what discovery, meaning photographs, reports, police reports, let's say in a car accident, and if it's being exchanged. Also, we dealt with motions if they weren't getting what they needed right away, or let's say, John, if someone didn't respond to any of it, the other side would make a motion to dismiss the case, or for what's called a default judgment, because they didn't do what they were supposed to do.
Now, when you talk about a court system, there are various courts. Why don't you give an explanation as to the various courts within the court system, with particular emphasis basically in the New York area? As you indicated, you've worked in the Brooklyn and the Bronx, and those are 2 of the most significant counties actually within our 5 boroughs. So why don't you explain the different court systems?
Well, actually, I started in Bronx Civil Court. That's the lower court. It goes up to, if you're suing for $25,000 or less, that's what they call the jurisdiction. Then after that, if it's more than that, then you go to Bronx Supreme Court. And if you're seeking more money. In criminal court's criminal court. It deals with misdemeanors. Felonies go to criminal supreme.
Now, you talk about civil court. What are the types of cases, as you may recall, that were in the civil court, and then give some sense as to what the distinction may be, if anything, other than the amount of money being sought between civil and supreme?
You know, that's a great question. I apologize for not expanding on it a bit more. Well, in civil court, interesting, they have different parts. You can have the matrimonial part, a personal injury part. They also have, there's different little branches too. There's also hearings involved with both civil civil court and Supreme Court. And I keep saying civil because you also have criminal court, and then you have Supreme Criminal. That's the one that handles felonies. But with the Bronx Civil Court and Bronx Civil Supreme, Civil Court also, there are branches. There's also Housing Court, which is a different animal altogether. As I said, there's matrimonial, the jurisdiction's the $25,000, and I didn't spend too much time there. I was fortunate enough to go, if you remember him, Judge Levy was my first experience. Mm-hmm. He was a wonderful, wonderful judge. And he was mostly medical malpractice, and he did mostly trials. He didn't do conference parts. So within Bronx Supreme, there's also then, I mean, I don't want to go on about it, but there's also the mental health, the mental hygiene hearings. And as I said, also a lot of different motions would go to Supreme Court as opposed to civil court. The weightier cases, you can say, go to Supreme Court.
You use a term, and when you use a term that strikes me that is something that would be of interest to a client watching or prospective client, you use the term conference, a conference part. So let's describe that.
So a conference part, if you walked in, I think everyone can imagine when you walk in, when you see it on TV, on all the legal shows, You have, when you walk in, you have the judge's bench up there, and then you always have the plaintiff and the defendant tables. Well, our role as court attorneys, we would sit facing, with our back to the bench behind us, and attorneys would then come up, the plaintiff and the defendant would come up, and we would conference it, whether, there's also mediation I didn't mention that, in Bronx Supreme. So they would come up, and if it was at the beginning stages of the case, they would see what they have as far as discovery, meaning the police reports on, or depositions also are a very important part of discovery, where I'm sure your viewers know what a deposition is, where you go in and under oath, you give your testimony as the other side questions you give testimony as to what happened, and then you ask questions and that sort of thing. So we conference it, we talk about it, they submit motions, decide them, and we try to resolve it without it getting too contentious.
What are the kinds of questions? And I can certainly envision, in having been in many courts, so you have the judge's part, and you've got you guys sitting there facing the plaintiff and the defendant's attorneys. How would you describe some of the kinds of questions and issues that the attorneys for either side may approach for you to consider?
Well, a good example is, let's say, with a car accident. If someone wants to know if you were on the cell phone when it happened, if the defendant was on the cell phone, and that is not automatically turned over. You would have to have a pretty good basis for why you'd be entitled to those records. Or if someone was on medication, you're not entitled to their medical records. So that's something that doesn't come up actually that often, but a lot of times the plaintiff says you're not entitled to that and they don't want to give it. So they might go back and forth, and then they might have to do some research and submit on a motion. And a motion, just to briefly say, is where both sides submit papers. Let's say the plaintiff is moving to get something from the defendant. Let's say I'm trying to think of an example, but they make a motion saying we're entitled to that. They give their reasoning, then they give, hopefully, good research, the law, and the defendant then submits opposition papers to it, why they're not entitled to it. They submit it to the court, and oftentimes we would draft a decision. The court attorney would draft a decision for the judge to look over, do their own research, and then make a decision for them. And that, I'm sorry, go ahead.
No, I was going to say that, so let's put ourselves in a situation. I'm one of the attorneys, plaintiff or defendant, doesn't matter, and I come up and we're having a conference call and we're going to put an issue in front of you. How long basically would it take from the time that the issue is presented to you until they get an answer on that particular issue?
You mean if they submitted a motion?
Yes.
Well, it is very, very, unfortunately, it can take some time depending on the difficulty. A lot of times with, let's say, labor law cases, when you have a construction site accident, it involves, if someone falls off a ladder, well, you have different subcontractors, and there are different things involved, so it may take longer. If it's a simple motion, someone submitted their answer, let's say, late. It would depend. If it was, a lot of times they can be orally decided as well with a short form order, but it can take. Unfortunately, that's one thing the plaintiff, people's clients need to have is patience. That the courts are very. So
might it take a week? May it take a month?
It could take anywhere from a month to 6 months. Actually, John, I'm sorry to say that it really could take quite a time because we're so backed up. We were so backed up with motions and.
Who makes that decision? The
ultimate decision is made by the judge, but most of the time I would think the court attorney, we work for the judge, drafts a decision, does the research, and then presents it to the judge, and whether she agrees with it, wants more research done, usually the court attorney and the judge discuss it, and then she signs it, makes changes, or he signs it and makes changes. So that's one thing I find most clients, most plaintiffs don't understand is the amount of time that it takes. It can really take a long time.
So if you were listening to a particular plaintiff or defendant attorney making a point, a motion, a point, do you generally come to a conclusion as you're listening to them? Do you reach a decision And then obviously you're going to draft something that'll ultimately go to the judge and then be presented. But the bottom line of it is, in most of the cases, did you pretty much have a point of view when you were listening to the attorney make the advocacy?
Well, that depends, because a lot of times, not often, but when the attorneys appear before us, it's so busy. Let's say our conference part, when I worked there, you could have 200 attorneys. You could have you could have 60 cases that in the morning. And the attorneys may misrepresent, or accidentally, of course, not state the exact facts as they were. So a lot of times it's cut and dried, clear cut, but oftentimes you would have to do some research. So a point of view, I try to keep an open mind.
There are some general categories of civil cases that I have no doubt you dealt probably with hundreds, if not thousands of them. Mm-hmm. And I'm kind of interested in your perspective. You've got a slip and fall case, mm-hmm. You've got a motor vehicle case, you mentioned before, a construction type case. Tell us, what was the overall experience that you generally had with regard to the category of cases? Which one tended to be the most, maybe which are the least? Get a sense as to the type of case that you dealt with.
Well, I would say the majority of cases were motor vehicle and slip and fall in the Bronx. But you did have medical malpractice cases. The construction cases were a lot more complicated, because as I mentioned, with the construction cases, you would have subcontractors and owners, different owners. Just imagine a construction site in Manhattan, or rather in the Bronx. There's just so many different, you've got, electricians, plumbers, the drywall people, you've got everybody there. With motor vehicles, it's more cut and dried. You have two cars that, unless it deals with, let's say, a rental car company. But oftentimes what happens, John, with motor vehicle is they can settle it beforehand, so it doesn't even get to us really. But the majority of cases were motor vehicle and slip and fall cases. You also had you don't see them too much anymore, but you used to have lead paint cases as well. Mm-hmm. So, but that kind of, as I know I've said it, but was slip and fall and motor vehicle. But the med mals were very interesting too.
What do you think someone who has a case, we can take a motor vehicle or a slip and fall, the primary type cases, what should they be thinking about as they move towards a litigation process? What should they be thinking about as clients? What should they maybe be doing as clients? Or if someone is in an automobile accident or has slip and fell and injured themselves, what should they be doing at that point to possibly enhance their case as it may proceed?
Well, I think the most important thing, and I'm not sure if it's really answering your question, is to have patience. Because it does, even from personally, it could take years, and it just seems to drag on. But actually, behind the scenes, people are doing things. There's the motions that are happening. A lot of conferences to settle out the discovery thing. But what they can do is, of course, number one is try to get better, keep up. Very important to keep up with their appointments, their doctor's appointments, every time they go, every time they don't, and any paperwork they should keep, and they should stay in touch with their attorney. I mean, there's not much they can do as they're waiting for the next step. As I said, the most important thing is to keep up with doctor's appointment, document any other problems they may be having with the injured part of their body. But other than that, John, I really don't think there's a lot they can do.
How important are photographs of the injury site?
Oh, that's very important. That's key, very, very key. That they take even from day one, when they, even if you're not sure if this is going to be, go to court or if it was anybody's fault, is you should immediately start taking photos, be it of the car, of your injury, and your progress with it. Let's say, there was an interesting case, and it was kind of gruesome actually, of a fella that had broken his leg. I remember it very distinctly because I had to look at the photographs. That he'd broken his leg so badly he had exterior fixture. He had these rods sticking out of his leg in the healing process. And he took so few photographs where the impact on that for jurors at trial, I know it impacted me, It's one thing to say it, but when you actually see it, so it's important to take photographs.
What about the photographs? Let's use an example of a slip and fall, a trip and fall. What should they be doing in terms of taking a photo of whatever the defect was that caused the accident? How should they do that, and what should they be looking for when they do that?
Well, you know, when you actually, when you fall, you might not be thinking of that right away, but if you're with somebody, or, oftentimes the injury might show up a day or two later, a week later it can show up, even 2, 3 weeks later, all of a sudden you realize that the limping is not going away, or let's say you went to your doctor or urgent care and they say you have whiplash, let's say if you hurt your neck, and only to discover if you start physical therapy that actually you have a disc problem, that you have a herniated disc. So the key thing is to go back and take pictures, but from all angles, especially with the trip and fall, because there's different grades of, let's say, an uneven sidewalk, a broken sidewalk, and while you're waiting around, they can go fill, let's say if you trip in a pothole, the pothole could be filled, and so especially important with snow and ice, to see what the condition of the sidewalk was. So if possible, they should absolutely take photographs, as many
I've
as they
often
can.
thought that one of the most effective photographs is not only taking a picture of the defect, but generally speaking, there is something that's uneven, and that really is what causes. And I've always felt putting that camera literally right down on the sidewalk so that you get a perspective of what the depth may be. It may be 2 or 3 inches, whatever.
It's
I've
funny,
always
John.
pounded away at that.
I was thinking de minimis, this, that, and I was going to say that, but I thought I'm not going to get into that kind of thing. Absolutely, because sometimes as you're walking, you don't even realize the defect or the bump or the depression in the sidewalk. And if the defendant goes and takes pictures, it looks like a perfect sidewalk. But when you, as you said, it's key, John, very, very key, is you do have to get it from all angles.
Yeah.
And that it would show how you tripped over it. So that's very, and something also, what people don't realize is stairs. If you trip on stairs, that people say, well, I tripped. Oftentimes the matting on the front of the steps, I'm not sure what you actually, the matting, the rubber that's there might be worn away. And looking at it, the defendant can go take pictures. It's there, it's fine. But when you take it, as you pointed out so knowledgeably, is if you take it from a different angle, you can see the depression, or you can see where it's worn away. That is what caused the trip and fall on the stairs, or, as you said, in the sidewalk. So it's very, very key, all angles.
Capturing the defect that caused the accident, whether that may be, and also you mentioned about an automobile accident, seeing where the bumper is that is defected. And so I think photographs are important. Let me change the role and ask you, how do you define the role of judges that you have worked with? Not a specific judge, but generally the role of the judge within the whole system of civil litigation.
Well, there's, let's say the conference part, there's a judge assigned to that, and then trials, 2 totally different aspects and involvement by the judge. The judge is there to oversee things. Hopefully they have good court attorneys that are knowledgeable and they trust them and they have a lot of faith in their ability. So the judge is there, let's say, for example, in a conference part, you can go to them for a question or a ruling on a specific question or rule of law. So they're there overseeing it. And of course, as they say, the buck stops with them. They're the ones that make the final decision on everything. So depending on the judge, they can be very, they can be very involved or not so much involved because they have other matters also to handle. With the trial, obviously, the judge is on the bench making the rulings and overseeing the whole trial. So the judge's role, different judges handle it differently. Actually, I didn't mention one part is the settlement conference part in Supreme Court. There, the judge usually has a very key role. They do, also, John, I know I'm jumping around a bit, but it's just coming back to me, is that depending on how big the case is, you have a lot of minor motor vehicle accidents, and then you have the huge ones that might involve a truck overturning, a van, that they would get more involved in, let's say. actually, with a trial, it depends. Not too many cases go to trial. And as I said, the most important thing I think a client has to do, part of it is patience. That a judge is key in the settlement process. They will conference back and forth. They'll try to negotiate it, that kind of thing. So it really depends on the individual judge how involved they get.
How have you found? Sometimes I have seen different approaches by judges over the years, but generally speaking, the demeanor of a judge, pleasant but moving the process forward, hostile somehow, and sometimes to the attorneys or to whatever. My question is, how have you found overall the judges that you've been associated with on a temperament perspective?
I've been very fortunate. I worked with, and many of the judges I worked for, they take different approaches, and I've been fortunate that none of them were really nasty or very hostile, but some of them wouldn't want to get as involved, or there was no, I never really witnessed personal animus towards the ninja, or they tried to hide it a bit, or they would then, if it was that bad, they would try to move it to another person. But the role of the judge and the demeanor of the judge is key, especially on trial. A lot of times judges get too involved in a trial and do not let an attorney just try his case. They interrupt, they ask questions. So the dynamic between the attorneys and the judge is very important. There were a couple of judges that would get overly involved or take exception, because really, if you're arguing your point, you really, sometimes the attorneys can get very animated, or they can get a tad hostile. And I've seen actually attorneys go at each other and get a little personal too, John. I'll say that. But most of the time, the judges really do try to be fair and even.
Do the judges just limit their communications to the attorneys, or do they have any direct communication with the client?
That's a great question. It depends. There's so many different parts of, I keep saying Bronx Supreme Court, but if it involves a young person, let's say, or usually mostly they deal with the attorneys. On a rare occasion, they'll want to speak. Let's say an infant compromise, or I have seen them. Let's say one time they always get involved is to see if a minor can testify, if they can testify, to see if they understand right from wrong. And now that's where the personality of the judge really comes to play, because depending on how you approach a child, it could be an 8-year-old. I once saw a 7-year-old, 8, 9, to see if they understand right from wrong, lying from telling the truth. Then the judge will directly speak to the child. Or if it's someone that may not be 100% mentally competent, they might be a little on the slow side, or they might be on the spectrum, and they'll speak to them and see if they understand the settlement, if they understand what's going on here, that sort of thing. So, but it's not often that they deal directly with the client. It's usually through the attorney.
You made the notion before about a conference work. What would be your sense of cases that are brought to you in the conference role that wind up going to trial as opposed to being negotiated?
Well, usually medical malpractice, because with medical malpractice, if you're suing a doctor as well, the doctor has to sign off on it. So he's not, and then that's on his permanent record, obviously. So that will usually go to trial. Medical malpractice usually will, also construction cases. And the bigger car accidents will go to trial, because if it's under a certain amount, it's not worth it for the insurance companies oftentimes to go to trial. It costs more to try a case. But definitely malpractice cases usually, unless it's so clear cut that it's, and it also depends on the reasonableness of the plaintiff's attorney. If it's a minor issue and he wants $5 million, well, obviously that's not going to happen. And in between that, before going to trial, as I briefly touched on, we have a settlement part that strictly deals with cases that are ready to go, they're ready for trial, and this is the last ditch effort to try to settle it, because very few cases actually go to trial. And then the court attorney will try, but the judge, there's usually a judge in the conference part, in the settlement part, that really gets down to the nuts and bolts of trying to settle it. But med mal is a big one that goes to trial.
Do you find the judges putting much pressure on the attorneys to settle a case?
Yes, yes. Yes, they because if you're going to try a case, then you have another long wait. They're very, very backed up, but sometimes the attorneys aren't being reasonable, and so the judge will put a bit of pressure on either side. The court attorneys also, I know I did quite a bit of mediation, and you talk to them, you try to. You point out the defects in their case and the positives, and you really try to come to a settlement, because otherwise the client will, it could be another couple of years actually before it goes to trial. I mean, from start to finish, a complicated med mal that can't settle could take 7-8 years.
Were you a good negotiator?
I think I was. I enjoyed it. I really.
What did you enjoy about it?
I was surprised how much I enjoyed it. It was because you'd come in, we'd chat, and then you'd speak to one side separately, and you could say things that you wouldn't say in front of both sides. You could point out something that they were missing that the other side didn't realize. You could point out the weaknesses, the positives. So, and it was much more of a personal, let's get down to brass tacks. There was no posturing. They weren't just trying to, because oftentimes the client might be in the courtroom while that's happening. I think it's up to the client to be there. So,
did you put pressure on attorneys as you were negotiating?
Well, it would depend. I wouldn't really put pressure on them, but if I thought, particularly if it involved children or a case that I knew it did not look good for going to trial, that they would be worse off, really. So I didn't really, I just spoke to them and pointed things out. I really didn't put pressure on them, but it was very successful. It really, and even the attorneys could get more personal rather than a big, courtroom with a lot going on, all these other attorneys there, and I took all the time that they needed. You could sit there for an hour, hour and a half. I often did it at lunchtime. And I just felt it was really worth the effort. Really worth the effort.
Did you get satisfaction out of doing negotiations and ultimately settling a case?
Great satisfaction. Great, because it usually meant that the plaintiff was in a great position then. It would, that they would, especially if they were badly injured, that, because until they settled the case, often they wouldn't have the funds, their insurance read out, if it was a motor vehicle, the coverage from the Motor Vehicle Act would run out, and they couldn't, a lot of times they were out of work, so they were almost destitute and facing years. There was a plus and a minus, because they might take less to settle it, but as far as I was concerned, I got great satisfaction from it, because everyone walked away, not happy, no one's going to walk away 100% happy, but satisfied that it was a fair and just settlement.
Do you think that the courts play an effective role in terms of both doing a trial when a trial is called for, or being involved in negotiating and settlement process? Do the courts do a good job?
Absolutely. That it also, when you think about it, John, you have so many different personalities. You have good attorneys, bad attorneys. You have attorneys that just want to settle a case, even to the detriment of that's why it's so important to pick a good attorney, and one that you can communicate with, that you trust, that they're looking out for your benefit and not just their bottom line. Whether it's a small case, some attorneys it's just peanuts. It's not a $1 million case. So the court, I think, almost protects people in a way, especially when it comes to children. But I think the court, to move it along, to give people a forum to chat about it, to talk about it, and to move towards settlement, and to iron out, let's say, back to the conference part and not settlement, to rather than make motions, if the court attorney knows the law, they can just, say, make the ruling right then and there, or encourage them very much with not pressure, but, a little pushiness, a little humor, throw it all in, and you develop a rapport with the attorneys. And if they trust you, then they can usually iron it out. So
What
yes
has
is the
been your
answer.
evaluation of the relationship between the attorney and his or her client?
That's a very broad question. After a while, you know the good attorneys and you know who is working on behalf. Often it's attorneys that are willing to go to trial. There are some attorneys that have never tried a case, you know they're not going to. There are other attorneys that absolutely will step up to the plate and will try a case and will usually be successful. They have that reputation. So that's the key thing, is the rapport they have with the client. And if the client's not comfortable, then it's that I think that's the most important part of the case, is to pick an attorney that you don't have to love them. It's like a doctor. As long as they're good and you know they're doing the right thing, then you don't have to, you're not going out and having coffee and dinner with them. But that's a key part, is the relationship between the attorney and the client.
How does a judge become a judge? How does an attorney become an attorney in court?
Well, a judge, they usually it's the whole process of they can get nominated by a political party, the Democrats or Republicans, but they get nominated, and then they have the judicial conference, where that's kind of I've been away from that part of it for a while, but then they get elected. They're on the ballot and they get elected, and a court attorney gets. I guess there's two ways. You get appointed if you're to a judge, or you can also go through the court system where they are looking for attorneys. Is you can work directly for a judge. A judge can hire you, or you can be that used to be called the law secretary. You'd be law secretary to a judge, but you can also, a court attorney is hired by the court to work. They can assign you to different judges, or they can assign you to a conference part. So you apply through the court, or you apply to a judge. If you can go on the website, the New York State Court System website, Office of Court Administration, and see the openings for court attorneys. And they'll post it, and you submit your resume, that kind of thing. So then
You've enjoyed your experience as a court attorney.
I loved it. From day one, I loved it. I did when I graduated law school, what the key thing for me was doing internships. And the minute I started doing it, I went to surrogates court first. But once I hit Supreme Court, I knew I loved it. I really enjoyed it. It was constant go. It was different attorneys, different cases. It was always a different kind of thing. It was never boring. And it was just, I loved it. I really enjoyed it.
So let me ask you a final question, which is, so in your experience, who is generally won? Plaintiffs or defendants?
In the Bronx, plaintiffs.
Yes.
No question, plaintiffs. Usually, plaintiffs. Because attorneys aren't going to bring cases that they're going to go nowhere. But it goes back to, John, you have to be comfortable with your attorney, and you have to, besides the rapport, you have to do a little search on it. And the best thing is someone, if you know an attorney or if you know someone else, their recommendation for an attorney. And as I said, looking them up and seeing what their history is, seeing what kind of law firm they have, and what you hear from the people that referred you. So I would say mostly plaintiffs in the Bronx.
Have you enjoyed getting into the facts of a case?
I loved it. It was, very much on the civil side. Criminal was interesting. It was different. They had a need for court attorneys, and they asked me to go to criminal court. But my first love is definitely the civil side of it. It was much more, I think, interesting. It was, I won't say cleaner, but I really enjoyed it. Because, as I said, you get, over the years, you develop a rapport with the attorneys, and you see some really good things. You see, people that were badly injured getting a good settlement. And that's always a win in anyone's book, especially, as I say, when it involves children or people that are disabled. So that's always a good thing. I loved it. I really loved it.
Do you think plaintiffs are, generally speaking, satisfied leaving Bronx County with the outcome?
Yes, I would think so. Sometimes people have unrealistic expectations. And, if they hurt their back or they have a little bit of whiplash, they think it's $1 million case because they've heard stories and they've heard someone that sprained their thumb and got $1 million. You have to be realistic about it. That your injury, and also, how much, let's say, insurance they have, the other side. So are they satisfied? Generally, yes, because otherwise they wouldn't agree to settle it, generally. But there have been disappointments, but usually I would say definitely yes.
The insight that you have brought as an attorney for as many years as it's been has been very informative and very helpful. Thank you very much, Deirdre.
Thank you, John. I really enjoyed it. I really enjoyed chatting to you today.
It was our pleasure. Thanks.
Thanks, John.